video, we talked about the first step in creating a mechanic lien system, which is to determine whether or not you should file a mechanic lien in the first place. One of the reasons we talked about is that your work or the materials that you supplied may not even be lienable. Now, in this video, we're going to talk about some additional reasons of why you may not want to file a mechanic lien. And one reason may be that your time limit has expired. If you'll recall in our introduction video, we talked about that there are certain rules that contractors and suppliers and subcontractors have to follow. A contractor who has a contract directly with the owner has 4 months to file his mechanic lien. A subcontractor or sub-supplier has 75 days to file to send out a pre-lien notice if it's required to, and we'll get into that later. And that subcontractor or sub-supplier has 90 days from the last day of work to file a mechanic lien. Now, those dates are non-negotiable. Those are statutory dates. You have to follow those dates or you cannot enforce a mechanic lien against anyone's property. And the consequences of filing a mechanic lien when your time limit has expired can be fairly significant. So we want to make sure that you're still within your time limit before you file a mechanic lien. If you're out of your time limit, then there's just nothing you can do. Now, you can still try to collect your money on a breach of contract claim, but you just don't have the right to file a mechanic lien against the property. Now, another reason why you may not want to file a mechanic lien is that you waived your lien rights in a contract. Now, a contract is nothing more than an agreement between the parties as to what the obligations and duties are to each other. I've seen a lot of contracts where one side will say that in consideration of you waiving your lien rights, I'll give you this job or this contract and move forward. So make sure you always read your contract to make sure that there's no language in there that would waive your lien rights. Another reason may be that there's no equity in the property. So, for example, a bank's mortgage. If I have a piece of property and I went to the bank and borrowed the money against it, and there's no equity in the property, then a contractor or subcontractor has to make a business decision whether it wants to file a lien against the property. An example might be that a property has a mortgage of $100,000 on it, but the property is only worth $100,000. Well, since that bank has priority, if it filed its mortgage before my lien, then it's going to get paid first. And as a result, there may not be any money for me. So again, you have to look at the economics, make sure that from a business standpoint, it makes sense to file a mechanic lien against the property if there's no equity in it. Now, I always recommend that you go to your lawyer and have him check the land records to make sure that you are familiar with who has a claim against the property. An easy way to do that is simply get a title report. Usually they're around $100, $125, and that will identify every person who claims an interest against that property and what their priority is. And if you see that you're ahead of everyone, then that's a reason to file a lien because you're more likely to get paid. But if you're at the end and all of the debt before you exceeds or is around the value of the property, there may be no equity and no reason to file a mechanic lien. Another reason may be that you give your lien rights away in lien waivers. Now, the typical process is that I do work on someone's property to improve it. I give them a payment application to get paid for it. They give me back a lien waiver to sign that says that in consideration of them paying me the money, I waive my lien rights against them for that money. The problem is a lot of times the person giving the payment and wants the lien waiver signed will put language in there that says that you give up all of your lien rights instead of just lien rights up to the date of that lien waiver. So this is an example of the type of language you may see in a lien waiver or a contract. The undersigned does hereby fully, finally, and completely waive, relinquish, and release any and all lien rights it has or may have against the contractor and the owner and the above described property relative to all materials and services heretofore rendered. Now, if you'll notice that there's no restriction on time. So for example, if this is a partial lien waiver, I would have the language to say that I am waiving my lien rights up to the date of this lien waiver and not beyond. And the reality is the owner is entitled to a lien waiver if he or she pays money for the work or materials supplied. So I don't have any criticism of that, but I want to make sure that you understand that it's important on a partial lien waiver to limit it into the scope of time, only cover the amount for that payment. Don't do just a blanket. I like the language here. This is a blanket lien waiver that waives all of your lien rights. Now, some language that we use a lot of times in lien waivers and in contracts is this: the undersigned does hereby partially waive and release any and all lien rights it has or may have against the above described property relative all to materials and services provided from the beginning date of said contract to the date of this is signed. And that limits the time where you release your lien. It's not an all-encompassing lien waiver. And then we also add this language here: except contractor or subcontractor, depending on what position you're in, is not waiving or releasing any lien or bond rights securing payment of retainage, because you usually don't get your retainage until the end of the job. So you don't want to give a blanket lien waiver for retainage, which is not due until the end of the job. Any unbilled changes, you may have changes out there that haven't been billed yet, even though you did the work prior to the date of the release. You don't want to give up any lien rights to those. And claims which have not been asserted in writing or which have not yet become known to contractor or subcontractor. So there may be claims out there. It's a back charge claim. There may be other claims that you're entitled to which haven't been asserted yet, that you have a right to assert somewhere before the contract's over. So you want to make sure you don't give up those lien rights. Now, this last sentence is important because we want to make sure you get your money. I mean, if they pay with a check, you want to make sure that the funds are actually put into your account. It says this lien waiver or this waiver shall be conditional upon receipt of funds to contractors or subcontractors' account. So you want to just make sure that you get the money in your account before you release your lien rights. So again, always on partial lien waivers, make sure that you limit it to the date of the lien waiver or to the date that you're paid up to, and that you reserve these other claims which may be out there. So that's language that we always recommend. Okay, in our next video, we're going to get into the next section about the next part of this 5-part process to create a mechanic lien system, and that is to get relevant and accurate information, because like I've said before, this is the most important part of this system, to make sure you get accurate and relevant information, because if you don't, nothing else matters. So it's important to really, really focus on this information. We'll get into that in the next video. See you on the other side.